Good morning, everyone. I'm Kaustubh.
I'm Karthik.
Today, we're presenting the case Chebrulu Leela Prasad Rao v. State of Andhra Pradesh, which dealt with reservation in tribal areas. This landmark judgment questioned whether the state could give 100% reservation for scheduled tribe candidates in teaching posts.
Let's look at the background. In 2000, the Andhra Pradesh government issued GOMS number 3, reserving all teaching posts in scheduled areas for ST candidates. Non-tribal candidates challenged this, pointing out that similar attempts in 1986 and 1998 were already struck down by the courts.
The key constitution provisions involved were Article 14, 15, and 16, covering equality and non-discrimination, along with Schedule 5, which gives the governor powers to make special provisions for scheduled areas.
Petitioners argued that 100% reservation wiped out merit, violated fundamental rights, and exceeded limits set by earlier judgments like Indra Sohe. They also said that the governor can only tweak existing laws, not make entirely new ones.
On the other hand, the state defended the order, saying that it was vital for tribal development, ensures teachers staying in tribal schools, and was backed by governor's authority under Schedule 5.
The Supreme Court struck down the 100% reservation as unconstitutional. It ruled that the governor can only modify, not create laws, and reservation can't cross 50%. Completely excluding non-ST candidates was discriminatory.
The judgment reinforced that while special measures are allowed for tribal welfare, they can't override fundamental rights. It balanced social justice with equality, drawing a clear line on the extent of reservation.
That's all from us. Thank you for your attention.
Hello everyone. Today I'll be speaking about the case of Shilpa Shailesh versus Varun Srinivasan, which was held in 2023 based on the grounds of irretrievable breakdown of marriage. So, coming to the second slide. Coming to the case overview, this case asked a crucial question whether the Supreme Court can grant divorce even when the ground of irretrievable breakdown is not specifically mentioned in the Hindu Marriage Act. The issue revolves around whether the Supreme Court can bypass statutory procedures in cases where marriage has clearly failed and it is beyond repair. Coming to the third slide. Okay, coming to the key facts. In this case, the Supreme Court examined its powers, which come under the Article 142 of the Constitution. Uh, Depending upon that, it focused on whether divorce can be granted with or without meeting all statutory conditions like mutual consent or cooling off period, etc., especially in situations where the marriage is beyond repair. Coming to the fourth slide. Okay, coming to the constitutional and legal provisions that were involved in this case, the key legal provisions involved were Article 142 of the Constitution, which was allowing the Supreme Court to ensure justice, the Section B of the Hindu Marriage Act, which mandates a 6-month waiting period for mutual consent divorce. But notably, irretrievable breakdown is not listed as a valid ground under Section 13. This conflict is what brought the issue to the forefront.
Hello everyone, my name is Sanket and I'm going to tell about this judgment taken by the Supreme Court. In this case, Supreme Court exercises the Article 142 of the Constitution, which allows the court to take any decision or orders or pass any orders to deliver complete justice to the citizens. The court held that if a marriage has broken to a irreparable or irretrievable form, it can grant divorce, especially when both the parties have arrived at that decision. Also, an important part of the judgment is that uh, it considers parameters like the length of separation, litigation history, welfare of children, and whether continuing marriage would be helpful or not. It is also it also waives off the cooling off period, which has been mentioned in the section 13b2, which is of 6 months, and grants immediate divorce under exceptional cases. So, what was the impact on the family law? There was a significant precedent for a quicker resolution in fractious marriages and a getter dignified closure. This actually this shows that the court is prioritizing human dignity and well-being over rigid procedures. Lastly, this expands how Article 140 is used, showing that it's not only a theoretical power but that has a real impact in protecting individual rights and prioritizing justice practically. In summary, To sum up, this was a landmark case that clarified an important legal point. In Shilpa Shailesh and Varun Srinivasan case, the Supreme Court granted a divorce, citing irretrievable breakdown, even though it's not a statutory ground under the Section 30. This decision shows a shift towards practical and compassionate justice, especially in cases where legal formalities only prolong suffering. In short, it's a win for individual freedom, judicial efficiency, and progressive interpretation of the law. In I would like to conclude my words that by saying that justice denied is justice delayed. Thank you.